Hello, everyone. This is Chapter 8 for Week 7, and it is all about workplace law and ethics. As I get into the slides, I want you to know there's lots of dates and things. I'm not asking you to memorize them all, but at least refer back to them for testing purposes and remember a few of them that are key. This is about professionalism in the workplace. Obviously, discrimination should be avoided. Privacy should always be maintained. The cultural and religious differences have to always be respected. There are some effective hiring practices that are maintained by most of the people who are out there today interviewing and hiring for jobs. They usually have a two-tier process where there's someone that's on board just to do some screening, and then secondly, the person who would maybe directly supervising you might be your interviewer, and there's certain guidelines that they have to follow. One of the things they do have to let you know always is what the disciplinary actions are in progression, like a verbal warning, first written warning, second written warning, and then termination. And it would behoove you to become familiar with some of the legal interview questions, things that can be asked or not asked, legal or illegal interview questions. There's a pretty good list here. If there's an L in parentheses, it's perfectly legal to ask. If there's an I, it's a no-no. When there's an L and an I there, it's kind of like a catch-22 situation. Sometimes it can be asked in such a way as to not be overt. For example, age. It's illegal to ask someone what their age is because there's a discriminatory process that can occur. But you can say to them what year did you graduate high school, and it can be kind of figured out that way. All right. We're a little bit too loud. 1 minute. Move this down a little bit. Okay. All right. So for the equal opportunity and employment discrimination, the government will regulate against that type of a pattern, if anybody should adhere to that. But it does affect laws that are in place for recruitment, pay plans, benefits, pensions, et cetera, and termination. And basically, what it's saying is that any person who is hired for a job has to be judged primarily on their performance, not on anything else. Most states now have the employment at will concept, which means you can either hire someone at will, or you can be terminated at will, whether the employer does the termination or the employee walks. If this is one of the concepts that is adhered to at your place of employment, there doesn't have to be a 2-week notice. I mean, it's the right thing to do, but it doesn't have to be. It's an employment at will. It can be terminated or begun by either party as they wish. Now, moving on down to the Title VII of the Civil Rights Act of 1964, it does prohibit discrimination or any unfair treatment based on race, color, religion, national origin, or gender. There are some exceptions. It does forbid discrimination in all aspects of patient care in any institution that gets any federal assistance like Medicare or Medicaid, and that covers most nursing homes and hospitals. And of course, it makes sexual harassment a form of discrimination. So this Title Act 7. That's my dog. Sorry about that. All right. So 1972, there was the Equal Employment Opportunity Act, which means that anyone who has had their Title VII rights violated may bring a lawsuit. Moving on to Pregnancy Discrimination Act of 1978 says that pregnancy does not hinder employment. A woman cannot be forced to quit, and they have to ensure equal treatment and equal coverage. There is a Civil Rights Act of 1991 that awards compensatory and punitive damages if a lawsuit should ensue. If there is a loss of income because the person has been terminated or discriminated against, and they have had emotional pain, which certainly is part of it, and suffering, that would be compensatory. Punitive punishes the defendant and deters anybody else holding up a red flag saying, this is what so-and-so did, don't do it or you'll get your wrist slapped too. So compensatory and punitive damages would be something that I would certainly pay attention to. I like the next one, the Age Discrimination Act of 1967, saying that anyone that's over 40 cannot be discriminated against. Yay! And it occurs and applies to employers that have 20 or more employees working for them. The Rehabilitation Act of 1973 prohibits discrimination based on disability in institutions that receive that federal assistance, nursing homes, hospitals, clinics, etc. There is the American Disabilities, the ADA Act of 1990, saying that employers that have 15 or more employees cannot be discriminated against anyone that has a disability. The employer has to make a really reasonable accommodation, such as ramps and ways to get in so that work can be accomplished, a wheelchair accessible bathroom, etc. Once in a while, there's an exception made if this is a particularly undue hardship for an employer. An accommodation can be made to help them with that. AIDS patients are protected under this ADA Act of 1990. The National Labor Relations Act of 1935 gives the employees the right to bargain collectively and to form a union, and the purpose is to really protect the employees. And it does establish rights for both the employees, the employers, and it defines some prohibitive acts by employers called unfair labor practices. It's also called the Wagner Act. Now, this you'll be familiar with because it leads up to our OSHA question and answer here, but this is about employee health and safety. It's regulated by both federal and state statutes. The state may be stricter than the federal in some instances, but it can never be more lenient, which is also very excellent to know. Leading up to the OSHA Act, Occupational Safety and Health Act of 1970, says that all employers are required to provide a safe and healthy work environment. And that includes, like for you guys, protection against bloodborne pathogens standard. So you would have personal protective coverings and always gloves and goggles available, et cetera, et cetera. CLIA, which is the Clinical Laboratory Improvement Act of 1988, 1992, requires regulation of all clinical laboratories that test human specimens. And it says there has to be a written policy procedure manual that will produce comparable rights from Laboratory A, Laboratory B, using the same piece of equipment or same set of instructions, should be able to produce the same type of parameters for results within a standard deviation of generally 1 or 2. The HMO Act of 1973, Health Maintenance Organization, says that any company that has 25 or more employees that provides insurance options for their workers also has to provide a comparable HMO, which would allow them to choose either their insurance provider, maybe by Blue Cross or Blue Shield or Cigna or whatever, versus an HMO like Kaiser Permanente. The COBRA Act of 1985 says that any company that has 25 or more employees has to provide extended health care available, usually at the employee's expense, for anyone who has either gone to part-time or has been terminated. And this is really just to make sure that they don't lose their insurance coverage. They can continue on for a period of 18 months or longer, but it's at their own expense. It's pretty spendy. There is a Drug-Free Workplace Act of 1988, and it says that if there is a drug-free workplace that is instituted, and most places have that now, it is important that the employer let the employee know about that and what would happen should there be any penalty. And it stands to reason that any place that is a government workplace always has that without any question. All right. The Social Security Act of 1935 is the very first groundwork that was laid for unemployment compensation. It is paid for by the employer and the employee, and the amount at retirement is based on the average wages that someone has earned during their lifetime from all their different places of employment. There is an FLSA Act, Fair Labor Standards Act from 1938, maintains, it's the main statute, regulating all employee benefits. It does, this is very important, and you'll see it up on everybody's wall in their break room. It establishes minimum wage, requires pay for overtime, sets maximum hours that an employee can work, and it covers the non-management employees for profit and for not-for-profit institutions. And it does only affect a full-time hourly rate employee. The Equal Pay Act of 1963 basically says you cannot discriminate based on gender if they're performing the same job. So a man and a woman doing the same job should be paid exactly the same. Unemployment compensation is listed here. The important things: the employers pay taxes into a state compensation plan, and it does cover employees that are unable to work through no fault of their own. If they are terminated, they usually are not entitled to benefits. The FICA Act of 1935, the Federal Insurance Contribution Act, requires employers to pay into a Social Security plan for their employees, and the employers contribute as well, but at a much lower rate. It has to be taken care of on time, or there are fines. Workers' Compensation Act protects workers and families from financial problems resulting from any employment-related disease or injury or death. The employers do pay into a fund to help cover costs. Obviously, the goal is to get the worker back to employment as soon as possible. Okay, moving on down, we have the Employee Retirement Income Act, or ERISA Act of 1974. It regulates the benefits and pension plans and guarantees vesting at a certain point when the employee has the right to receive those benefits from a retirement plan. That's kind of when the employer pays and matches your contribution. It's generally either 2 or 5 years. The Family Medical Leave Act of 1994 allows the mother and the father to take a leave of up to 12 weeks in a year period when a baby's born. It is usually not a paid leave unless vacation or sick time is put into that too, but it allows leave for not only for pregnancy, a family-related illness can also be covered here. Excuse me, I'm going to take a drink. All right, a lot of dates here, huh? Moving on down, the Emergency Medical Treatment and Active Labor Act. It's a section of COBRA, and basically this one forbids a hospital or a clinic from dumping one patient to another facility because they just don't want to take any more patients that can't pay. That is illegal. Forbids this. The Fair Credit Reporting Act of 71 establishes guidelines for use of an individual's credit information. If an individual is denied credit, the consumer has to be notified, and the agency that they have chosen to get their report from has to disclose the credit information that is detrimental to their report. They may have an opportunity to correct and update that at that point. Equal Credit Opportunity Act of 75 says that women and minorities have to be issued credit if they qualify for it. They cannot be discriminated against based on race or gender. The Truth in Lending Act, called Regulation Z of 1969, requires full written disclosure about interest rates, the finance charges, anything that has to be concerning payment. And generally, your banks or your credit cards, if they change any of their interest rates or any of their procedures, they have to let you know by mail. Written disclosure. The Fair Debt Collection Practices Act of 1978 prohibits unfair collection of practices by creditors or institutions against people who are needing to pay, but for whatever reason can't. And the horrific practices that used to happen, where they call you in the middle of the night or call your mother-in-law or whatever, are illegal now. Now they can only call Monday through Friday between 8 a.m. and 9 p.m., and any form of harassment is completely illegal and prohibited. If you are working for someone where you've tried every last way to collect money for a bill owed, and you finally turn it over to a collection agency, there's a procedure to follow. Usually it is a letter that is sent out, registered return receipt requested, meaning that the person who's receiving the letter has to sign for it, indicating that they can't say they didn't get it because they signed for it. And then once it goes to the collection agency, anything that you have to say about the collection procedure stops. It's in the collection agency's hands at that point, which is what I just covered here. Now, for bankruptcy, when a person cannot pay any of the debts that they owed, they may file for bankruptcy. It provides some protection to the debtors, which means that any of the assets from the person can be put into a special fund, and it's court protected with a trustee who then distributes the money according to a predetermined method back to the people who are owed. Phoebe Bryant. Federal Wage Garnishment Law of 1970. The court requires the employer to pay a portion of the employee's paycheck directly to one of the employee's creditors until the debt is resolved. This may, one of the things that happens here is for fathers that need to pay child support. The claim against an estate when a patient dies, bills have to be sent directly to the estate of the deceased, and usually there is a specific time that is allowed. There is a statute of limitations that defines how long a medical practice has to present or file a lawsuit on a past due account. So it would be important for you, if you're working in a facility where monies are owed, to try to collect those debts from the estate as soon as possible. That's it for Chapter 8. I hope that you enjoy this archive, and I look forward to hearing from you this week. Take care and have an excellent weekend. Happy Mother's Day to all.